temporary order from the court directing the school board in Detroit to implement the plan that it had come up with, the modest desegregation plan. We went to his chambers. He was in Flint, Michigan. His name was Steve Roth. We went to see him. We had all the papers. And he looked and he said, "Why'd you wait so late?" He says, "School's going to start in 2 weeks. I'm not automated. I can't read all of this and decide in that period of time." He said, "Furthermore, I don't think you can win." He said, he said, "I've been Attorney General of this state. I've been a common pleas judge before I was a federal judge. And I know the good people of Michigan. They would not do to black children what you say they've done to them." And so he denied it. But he did set it down for a hearing. And in the meantime, we called Cincinnati, the clerk's office, and asked if we could have an expedited hearing for the court to consider the judge's refusal to order the plan into effect. So in about 10 days, we had a hearing. It was a very fine panel. Someone you know, Judge George Edwards, was on the panel. Judge Wade McCree was a member of the panel, and Judge White, who was on the opposite side of everything, civil rights, was on the panel. But the court overturned the district judge and said, "You've got to go to trial. You've got to reconsider this matter." That was the beginning of the famous Detroit case of Bradley versus Milliken, which went to the Supreme Court twice, and it was what I called a judicial betrayal for the Supreme Court, an opinion written by Chief Justice Berger, to overturn what the Sixth Circuit had ruled en banc, that the Detroit plan, the Detroit school system had been so egregiously administered that the only way a remedy would work was if they did not limit the remedy to school district lines. In other words, could they involve the suburbs, a metropolitan case, in other words. And the Supreme Court just couldn't handle that. And the great disappointment in that, one of the great disappointments in that case, and the reason I feel so deeply about it, because that's the case I argued, was Justice Potter Stewart. Justice Potter Stewart had been very good on civil rights cases up until that time. He wrote the famous opinion in Shelley versus Kramer on restricted covenants. And his civil rights record was very good. But he said in his concurring opinion, when you reach the point where you're going to order suburban children into schools in inner city Detroit, that's where I get off the bus. And he was the fifth vote we had counted on, and we lost it. And because we lost that case, it reshaped public education in this country. From now on, I don't see a change now in terms of how you remedy school segregation, except that the educational reformers, those who were trying to bring about reform and adopted such things as the voucher system, they are using the very same techniques that would have been used if the metropolitan plan had gone into effect. Because you get a voucher and you can go anywhere you want to go, anywhere the schools will take you and will receive you. So I focus on that because education, as Marian has pointed out, has been key. It's been a central objective of black people. Getting an education, like your grandfather told you, get an education. But early on, that effort was frustrated. It's been hobbled throughout the years in one form or another. Now we have, well, tonight we're looking backward. I think before we conclude tonight, I'm going to take a little leap forward to point out how the past has affected the present and the future. In 1980, Ronald Reagan launched his campaign for the presidency in Mississippi in a speech in which he said he was going to bring about a major change in the makeup of the federal courts. He was going to get rid of these activist judges. Who were the activist judges? Thurgood Marshall, Brennan, the judges who had, Douglas, all these judges who had voted for Brown v. Board of Education and who had voted to support other changes in our institutional structure that had been shaped by these segregation laws. Those were called activist judges. And when you look at the Supreme Court now, you see that his promise of 1980 has been met. We now have a Supreme Court, the chief judge of which says the way to stop discriminating is to stop discriminating. Well, that brings about a deadlock, because if you can't alter the condition that offends the Constitution, then you perpetuate it. And that's where we are now. And he's joined by his colleagues, Judges Justice Scalia and Clarence Thomas, who succeeded Thurgood Marshall. And I often say that when we had Thurgood Marshall, we had a black justice, but we don't have a black justice now on the Supreme Court, because he aligns himself with the most conservatives. In fact, he's even more conservative than the conservatives on the court, because his thesis is, and this is where he and the conservatives have found common cause, that when a remedy, whether it's in employment, or education, or anything where you're dealing with numbers, where a remedy disturbs the status quo or impacts on whites, the white majority, that's a form of reverse discrimination. That is denying the whites their rights under the 14th Amendment, when the 14th Amendment was ratified to protect blacks. So instead of the 14th Amendment being a tool for change, it's become a barrier for remedying situations, and particularly in education. And now we see it in the election field, where the Supreme Court just last week, 2 weeks ago, reversed a decision by judge economists here in Ohio on early voting. And the Supreme Court, and the Sixth Circuit affirmed judge economists. But then a group of the judges on the Sixth Circuit went around their chief judge and went to the Supreme Court, and the Supreme Court undid what the Sixth Circuit had done, and that was permit that plan to go into effect. And so the efforts to ensure that minority votes in Ohio will not be suppressed has been put on hold. So that's why I say we jump forward. So this all tracks back to the notion that race is a no-no. This business that, well, you can't use race because it penalizes white majorities. When race was present at the very beginning of this state, beginning of this country, that led to Dred Scott opinion, and to pretend now that race is irrelevant and we shouldn't use it because we are punishing innocent white people is a mythology. And okay, the sermon's over.